Hi, my name is Larry Newman. I'm an attorney. I'm located in Ithaca, New York. I'd like to talk to you about the burdens of proof in a civil case. In any type of legal case, whether it is a criminal case or it's a civil case, the person that wants something has to move the case forward. They have the burden. So in the case of the government going after somebody and they want to prosecute them for a crime, the government has the burden of proof, and the government's burden of proof in a case like that is to prove every element of their case beyond a reasonable doubt. Well, similarly, in a civil case where we're looking for money as compensation for damages from an accident, the person that represents the person that got hurt, the victim, they have the burden of proof, and their burden is called a preponderance of the evidence. And what a preponderance of the evidence means is a little more likely than not, or if you're looking at the scales are just tipped a little bit over in one direction versus the other, a little bit more likely than not that these are what the damages are from this particular accident. Remember, in New York, we have a thing called pure comparative negligence. So we don't have to be totally 100% not at fault for an accident. Even if we're at fault for an accident, we can still collect the percentage of damages that we're not at fault. If we're 70% to blame, we can still look to collect 30% that we're not to blame for an accident. But then the second part of that is always going to be we still have to prove our damages to a degree, to the preponderance of the evidence standard, to show more likely than not that these are the damages, that more likely than not these are what the things are going to be, these are outcomes for the future. If you have any questions about your personal injury case or DWI matter in upstate New York, this is what I do. I'd be more than happy to answer your questions.